So good evening, ladies and gentlemen, thank you, and young lawyers. My name is George, in fact George Daly. As you can see, I'm totally the opposite of young, but it's by pure coincidence I am exactly the same age as legal aid. So I have very good reason then for being here celebrating its life so far. So we are going to reflect on 60 years of legal aid and say to it, as it were, this is your life. Now, legal aid, of course, had humble beginnings and a pretty troubled childhood. But with the help of many friends who championed the cause, many of whom are sitting here today, legal aid at least has succeeded so far in benefiting the lives and liberties of many of those who would otherwise have had no access to legal redress. And, of course, in recent years, legal aid has been often criticised for being failing, past its prime, and in great difficulty. So tonight we'll be really focusing on the question which is close to my heart, and I'm sure to many of yours, which is there any life after 60? So as with most living things, a lot of interesting things happen before birth. And so we'll first go back into deep history and look at the activity which sort of preceded the birth of legal aid. The idea has in some ways been around for an awful long time. You have to go back to the 4th century when the Emperor Valentinian introduced an office called defensor. The idea there was to defend towns, churches, and what was then called the lower classes, perhaps, against powerful government functionaries. In the Middle Ages, hundreds of years later, this was, of course, partly enshrined in Magna Carta, 1215, with the famous declaration, "We will not deny or defer to any man either justice or right." However, of course, the medieval legal system wasn't all that friendly to the litigants, and in those days, poor, failed litigants could be flogged for losing their case. Then, for many hundred years, the representation really of the poor was left pretty much entirely to the goodwill and generosity, charity of lawyers. Back in 1648, a lawyer called John Cook, very rarely remembered now, but he was the lawyer who led the prosecution of Charles I, was one of the first people to suggest a pretty embryonic legal aid system by suggesting that all barristers should be required to spend about 10% of their time doing effectively pro bono work. But it's really, of course, not until this recent century, 1926, that the process became more formalised with the Findlay Committee, who made recommendations then just for criminal legal aid. And the result was what sounds like the amazingly patronising 1930 Poor Persons Defence Act. Whereas at that stage, and from then on, representation for poor in civil matters continued to rely entirely on lawyers acting pro bono. By the 1940s, the Haldane Society, the Society of Socialist Lawyers, of course, came to the rescue to some extent by declaring and advocating that for the poor to depend on charity for legal advice was clearly wrong in principle. So in 1944, Lord Rushcliffe set about laying the foundations that made legal aid really what it is today. And the Rushcliffe Committee had 3 main recommendations. Firstly, that legal aid should be available in all courts, civil and criminal. Secondly, that it should not be limited to people who are extremely poor. And thirdly, that lawyers should be adequately remunerated for their work in this field. So could you just raise your hand if you think the third of those has been successfully achieved? Probably not. So legal aid really officially became a reality, a social and legal right in 1949 with the Legal Aid and Advice Act receiving royal assent.